Today we're going to continue with our Ask a Lawyer series, and we're talking to Dan Cuneo, who is an attorney with the law firm of Cordell and Cordell PC, a family law firm focusing on men in divorce. And today we're going to look through some of the Ask a Lawyer questions that have been submitted through the site, and we're going to pose those questions to Mr. Cuneo. The first question, and the first two actually have to do with the payment of child support and payments of alimony, and they're questions that have to deal with whether or not those amounts that are that the judgment deems that person responsible for, if those amounts can be altered. The first one is, I just went to court for custody of my two boys. The court granted my request to be the primary parent of residence. The court ordered my ex-wife to pay child support. I know she will not cooperate and pay the support. Presently, I am paying her limited duration alimony. And the question is, can I deduct the child support from the alimony payment? And he says, I don't see any other way to enforce the order unless I'm allowed to just cut back her weekly alimony payment. Dan, what do you think about that? Is this guy allowed to stop paying some of his alimony because he knows his wife isn't going to be paying the child support that she's supposed to pay?
Well, you know, we get a lot of clients who come in wanting to know if they can just go ahead and deduct payments, whether it be from the alimony or maintenance, what it's called today, or from the child support payments, whether it's because mom owes for past medical bills or for whatever that she would be responsible for under the decree. So the short answer to it is no. If there's money that is owed to this particular person, then the proper remedy is to file the motion with the court. And it's going to be really dependent upon what does the decree say. Does the decree say that mom is responsible for half or a certain percentage, or is she responsible for certain bills? And if so, what are those bills and how much do they add up to if it's identified in the decree? And if it is, then what dad will need to do is file a motion for contempt and file a motion to determine amounts due and owing. And that way, it brings to the court's attention that here's this order, here's what mom is supposed to be paying or responsible for, and here's what her actions are. And her actions are the fact that she's well aware of that there's this decree entered, whether it be by trial, which was ordered by the court, or by a settlement agreement, which the court has signed off on and will be enforced as a court order. And courts don't take it light when someone is disobeying one of the orders, especially when they're well aware of the fact of what's going on in their order. So in this particular case, no matter how much or how little or whatever the amount of the alimony is, you cannot deduct monies that is being owed to you out of the alimony. And the same thing for the child support payments. If a mom would owe you any amount of money, then you can't deduct that amount from the next child support payments.
I understand. So the idea basically is, let me ask you a little bit of a follow-up, because I know I see sometimes on the site people will, and this is oftentimes people are sending in questions to ask a lawyer, and it's usually they're asking for advice because things got a little bit muddled up. And I notice sometimes that there's a trend maybe where parents, two ex-spouses are, maybe it's after the divorce and now they seem to be getting along and things seem to be working out, and there's some give and take and some altering of, well, you know, you paid this, so I'm going to go ahead and pay that. And do you recommend that they, what would be a way that they could stick to the letter of what was handed down from the courts, but yet also, I mean, is there any room for making an adjustment here and there, or do you just recommend that they don't do that?
Making adjustments for is what is being owed to them and deducting anything from alimony or child support?
Like sometimes, you know, maybe an unexpected expense comes up and dad took care of that, and mom says, well, okay, so you don't owe us so much this month, you know, take that off. Do you recommend that they not do that, or how could they deal with that?
Right. Well, as we talked about before, you don't want to deduct anything that is for alimony or for child support. If what you're saying, if an unexpected expense came up, then what you're going to want to do is send mom an email or send her a letter or a fax, something to indicate that there was this expense, it wasn't identified before, and the proper way to do is to put in some type of writing. So one, you have a paper trail, and also you want to let mom be aware of the fact that there was this unexpected expense. Give her some time to pay for it, and then if she refuses or doesn't pay for it, then your remedy is going to be file the motion with the court, and that motion will be either a motion for contempt and or a motion to determine amounts due and owing.
Okay. All right. So basically, make a paper trail. Be sure that you're sending emails or some type of correspondence that you can keep a copy of.
Because if it comes down to it, and you do have to have a hearing, or you are in front of the judge, you're going to use that email, that letter, that response, that text message, whatever it is. You want to be able to show that to the judge that, I attempted to resolve this amicably. Here's the response I received. I waited to see if payment would be tendered. I haven't received anything, and here's why we're in front of you. Because at the same time, courts don't like people just rushing in and filing motions to the court. They want to see if people can try to work things out. Because the court dockets are flooded with several cases, and then by the time that you file the motion, get it heard, you're looking at several months, and you're also incurring litigation costs too.
Right.
And a judge could award a part of your attorney fees to be paid, but you won't get 100% of that back. So you're going to be incurring more money to try to get additional monies from mom if you can't try to resolve it amicably.
Okay.
So you could potentially be throwing good money after bad.
Okay. Okay. Good. So keep be sure that you have a paper trail if there's any kind of flex in the way money is being paid for maybe unexpected expenses. The second question tonight is maybe somewhat related. The writer says that he is recently remarried and he's about to have a new baby. And his ex-wife, he says, has a man living with her, and that they are that they're cohabitating and they're splitting bills. And his question is, can I have my child support decreased due to the fact that he's about to have another baby with his new wife, and the fact that his wife now has someone living with her and paying part of the bills? And he's saying he pays $714 a month for his child that his ex-wife has custody of. When this amount was set, it was just her income and mine that determined that amount. But now he's saying that there's new factors. So the question, Dan, is can he have his child support? Can he have it lowered based on those factors?
Well, that's kind of a multi-question right there. And what we'll do is we'll kind of take each part of it out. And the fact that he's having another child outside of the relation to where his current child was born, and that's what he's responsible for paying child support. The short answer to that is no. You're still obligated to pay child support. Right. Now, the fact that mom is cohabitating and living with another person, that factor alone will not help decrease child support. What you're going to want to do is, in Missouri, in order to decrease your child support, you're going to want to file a motion to modify. And what you're going to be modifying is the child support. Now, before you can get into court to file that motion, there's a threshold that you have to meet, and that threshold is 20%. Is the difference in child support payments going to be a difference of 20% or more? Meaning that in this particular case, if the difference was 20% from $714, then you've met the threshold burden right there. So then you can go ahead and file your motion to modify. Courts, that doesn't mean that automatically you're going to get a decrease in your child support. It just means that you've met the threshold to be able to file the motion to modify the child support. And so what the court's going to look at is the Form 14. And what a Form 14 is, it was a form handed down by the Missouri Supreme Court, which is a calculation or a formula to determine the amounts of child support that's owed. And so what the court will look at, if there was a Form 14, and if so, what was the gross incomes of each of the parties at the time that the Form 14 was entered by the court. And so what you risk, though, by filing a motion to modify is an increase in child support. If you file your motion to modify alleging that your income has gone up, has gone down, you have other expenses, mom is living with someone, and so that person is helping them pay the bills, so she's got more income imputed to her, you could be exposed to a liability for an increase in child support. So just because you've met the initial burden of 20%, there could be other factors taken into consideration by the court which would increase your child support as opposed to decreasing your child support. So before you do that, you want to come in and meet with an experienced family law attorney and do an analysis of what the risk is in order to file that particular motion to modify. And one thing which wasn't mentioned in the question is how old is the child or how old are the children? Because in Missouri, if the child is emancipated at age 18 unless the child continues on for a college education. Then the child emancipates at age 21